Hello everyone, the topic of my lecture is Sources of International Law. First of all, I will introduce some basic information about sources of international law. The meaning of sources under law has two kinds of category. One category is origins of law, and the other means expressions or forms of certain law. And let's make an analysis of sources of law's functions. To summary, there are three functions of sources of law. First, we can trace the development of law according to its sources. Secondly, we can compare the priorities between different laws according to its sources. And the last one, sources of law may be helpful to observe the whole legal system. When we talk about sources of international law, we have to mention the ICJ statute. ICJ means International Court of Justice, which is an international organization belonging to the branches of the United Nations. And ICJ statute is the international convention which has been recognized by the most of states in our community, in our international community. At the same time, ICJ statute can also have another functions. That is, it also can be regarded the Charter of International Court of Justice. When the scholars discuss the sources of international law, they will refer to Article 38, the first section. Article 38 brings us a very obvious evidence of the sources of international law. Now let's take a brief look at these regulations. The court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply a. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. Now, the first kind of sources of international law is international conventions or treaties. Here, there is the key elements we should pay attention to. That is, the international conventions or treaties should be recognized by the contesting states. That means not all the international treaties or conventions can be regarded as sources of international law. Only those who has got recognition of the most states can be thought the sources of international law. B. International custom as evidence of a general practice accepted as law. From these rules, we can know the second kind of sources of international law refers to international custom. This custom is different with international treaties. And C. The general principles of law recognized by civilized nations. This is the third kind of sources of international law. It refers to the general principles of law. Because the concept or definition of the general principles of law is a little complicated to understand, we will explain it in the next slides. D. Judicial decisions and the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of rules of law. The last rules about sources of international law is not the same with the first three kinds of sources of international law. As the provisions has told us, judicial decisions and the teachings of some scholars is not sources of international law. It is regarded as subsidiary means for the evidence or determination of rules of law. This slide shows the picture of ICJ, International Court of Justice, which is located in Hague, Holland. The scholars of international law has divided all kinds of sources of international law into two categories. The first category is called primary sources, which includes international conventions or treaties, international customs, and general principles of law. The second category of sources of international law includes judicial decisions and the schoolings of international publicists. And in modern times, we also refer to declarations or decisions of international conferences or international organizations. But here, we have to argue that the last one, declarations or decisions of international conferences or international organizations, is not so certain as the secondary sources. After all, there are some different opinions who thinks declarations or decisions of international conferences or organizations belongs to soft law, which should not be regarded as sources of international law. That's all. Thanks for your attention.